SJC-12604, Gammella versus P.F. Chang's China Bistro, Inc.
Mr. Churchill, good morning.
May it please the court. I'd like to reserve, with the court's permission, 2 minutes for rebuttal.
We don't do that anymore.
Okay.
We did it and it failed as an experiment.
Then I won't. So I would like to start with the principal issue in this case of what is the meaning and effect of the statutory language giving employees the right to bring a claim on behalf of others similarly situated, and more specifically, what is the effect or interplay between that statutory language and Rule 23, and specifically...
Can I ask, as a preliminary matter, I read your complaint. You seem to have treated this as a Rule 23 class action yourself. So is this something that just popped up on appeal? That it was, everyone thought this was going to be governed by the standards of Rule 23?
In the relief section of our complaint, we requested class certification pursuant to Rule 23 and 149, Section 150, and Chapter 151, Section 20. So we did reference those statutory provisions, and that was with an eye towards this language in the statute. In our motion for class certification...
Why would you have brought up Rule 23 at all? I'm confused by that.
There's a practical answer to that, which is there is no law yet in this jurisdiction about this particular issue. It's a question of first impression, and it has been, in my experience, uniform practice of those of us who bring class action claims in the employment context to pursue claims under Rule 23 while also referencing the statutory language in Section 150 and in Section 20 of Chapter 151. Here, the reason that it was, I think, different for us is the way we defined the class. There was no question as to numerosity. So it didn't raise the kind of situation where there were maybe 10 people in a class or 12 people in a class, where the tension between the statutory language and Rule 23 came into play.
Well, to state the obvious, Judge Laureate disagreed and says that the class is not people who worked less than 3 hours. The subclass is people who involuntarily worked less than 3 hours, so there's a huge numerosity issue.
I agree. The way he defined the class. The class that we proposed were all the employees who met what we think are the prima facie elements of a claim for reporting pay, which is that they were scheduled to work more than 3 hours and they worked fewer than 3. So what Judge Laureate then said is, well, that's not enough, because in order to get damages, you're going to have to also prove that it was involuntary. And I think that violates the settled rule in this Commonwealth that at the class certification stage, you do not need to meet the burden of proof that you're going to meet at trial. And there are a number of cases where classes have been discussed to include people who may not ultimately receive damages. In the Salvis case, for example, one of the issues there, and the reason that the trial court decertified the class, was because of a concern that there would be people in the class who were not ultimately going to recover because they voluntarily agreed to give up their break time.
But don't you need at least one other? I mean, you don't have anyone else that, I mean, that may be why the Judge Laureate pushed this a little bit. I mean, if your client is in a total class of himself, don't we need to define that somebody else would meet the definition and the regulation of the statute?
Well, I think that's where some reasonable inferences have to come into play here. But
isn't it reasonable that you'd find at least one other person? I mean, your client works in these restaurants. He must know somebody else. Isn't that a bit of a problem? Doesn't that raise the numerosity issue that Justice Lowy just brought up too?
Well, I guess there's a couple ways to answer that question. If the court's question is if we had one other person, that would have met the statutory.
Well, it would suggest that Justice Laureate's, yes, I understand you don't have to meet the burden of proof at trial at the class certification stage, but where there's no indication that anyone but your own client, I mean, I understand you brought out the fact that there are a couple of thousand people, I guess, or I can't remember the number you're talking about, who worked 3 hours and didn't get paid 3 hours. But you don't have anyone else in the mix yet who may have not volunteered to do this, right?
Well, so one,
Can I just ask, that in the record, does the defendant ever suggest that that group does not include people?
no, they don't, and that's an important point here. I think one thing that we established, I believe, through discovery is that P.F. Chang's did not have a practice of complying with the reporting pay. They didn't have anything in writing until 2014, which was the year that the case was brought. They were unable to show, even though they said if they ever complied, there would be an audit record. They didn't supply a single audit record. So to conclude that in 7,000 cases, there was not at least one other one where somebody was not involuntarily cut strains credulity, I believe. And the question of had we found one other or two others, that I don't think would have materially changed the analysis of whether class certification was warranted here or not. And I think it does get back to this issue of how.
Can I ask you a question?
Yes.
Is it your position that you meet the numerosity requirement and the other indicia for class certification under Rule 23, or that you would only meet it if there was this special right under the Wage Act?
It's our position that we do satisfy Rule 23.
Okay.
And specifically numerosity. And I think that's because the way classes are defined, and what's been certainly my uniform experience doing this for many years, is not, you don't have to prove everybody in the class wins and gets damages. You have to show that there's a common policy that they were subject to. And that's what we showed here. And I think the way Judge Laureate looked at it, it obviates the issue of commonality and predominance, because the way he defined the class was everybody who basically for whom there's no question they're entitled to damages. And if that were the case, we would never have to look at commonality and predominance because they're all the same. They're all in the exact same situation. The reason that the elements of commonality and predominance are there is because classes contain people who have different situations. And here we showed enough commonality because this was the class of people who are eligible to make a claim for reporting pay. We weren't defining the class.
But isn't this more complicated? Because it's kind of either you win or you lose in this context. Either you went home voluntarily or you were forced out home. So it's not like these classes where you've got 4 different types of classes who may have different ways of recovering. It's kind of an all or nothing, isn't it?
Well, there's a middle ground.
What's the middle ground?
People who were involuntarily cut and told, go home now, as our client testified happened to him, everybody agrees they're entitled to reporting pay. If somebody said, I'm sick, I'm gonna go home, I need to go home, and they say, fine, go home, we're not arguing under the regulations that person is entitled to reporting pay. But there's a middle unsettled area where somebody says, the employer says, we're not busy enough, we need to cut somebody. And in those circumstances, our position is there's an implied pressure there for people to volunteer to leave, and so they are entitled to reporting pay. I expect P.F. Chang's position is different. So it's not necessarily a simple either-or situation. And I think it's also important to note here that the reason it's difficult to go back and look at each of these situations to figure out what happened is P.F. Chang's kept no records of these circumstances. If they had complied with the reporting pay requirement, what I think a diligent employer would and should have done is to make a record of why the person was cut early. It was voluntary or was involuntary. And if it was involuntary, they should be able to produce a record.
Can I shift you to some of the complexities of this? So your client is fully compensated. and settled. The class certification is denied. You're proceeding to appeal that. I'm just trying to play this out a little bit, because there's again, I'm bothered by the fact there's no one else in the class. So you want to pursue this class certification, right? You want to be able to do this, and you're saying you've not been precluded from doing so, even though your case is over, right?
So there's two different issues. There was standing to appeal,
Right.
and I think that's not an issue because P.F. Chang says,
I understand in this case, it's not an issue because they sort of agreed to let it go, but
Right.
the U.S. Supreme Court has sort of been wrestling with this issue in
It
Rule
did.
23 class actions, right?
right, right. And in the Campbell-Ewald case, as the court was probably referring to, there they ruled that a Rule 68 offer of judgment that's unaccepted does not moot a claim. It's a nullity, essentially.
Right.
And here, I would note that Mr. Gammella never accepted the offer, so it's similar in that regard. And then they did go on to say that they weren't addressing the situation where a defendant puts money.
Sorry, but the judge dismisses your case, saying, right? The judge says your case is over with, even though you haven't accepted, he's dismissed your case, right?
Right,
Which is a little different than the U.S. Supreme Court cases, right?
right. Well, we argued that it was improper to dismiss the case in light of that authority from the Supreme Court because there was no mootness.
So you want to, but the reason it's improper is because you've got this pending class certification, right?
Yes.
And I'm just trying to play out how the next steps in this. Say you win the first one, so we decide you can appeal this, you have standing to appeal even though your case is done. Then you're going, and say you win, isn't there a problem that there's no other person and you're atypical? I'm just trying to understand how this is going to
No,
play out.
that's exactly the concern, Your Honor, because, and I expect that's why P.F. Chang's is doing this. And if you then play out, how can a defendant avoid class actions? If all they had to do was to,
I totally get why that's problematic, to let them knock out the named plaintiff, but there's no other plaintiff. That's what makes this complicated. There's no one else, and then you're going to be atypical. So it seems, the whole thing seems problematic.
But
It may
the
be
on-
correct, but
the only reason we're atypical is because that's an atypicality forced upon him by P.F. Chang's.
it is only forced upon him because there's no one, but it's more problematic because there's no one else.
But if there were three people, they could have done the same thing. There were
Yeah,
five
but-
people that could have done the
But if
same
there's
thing.
three people and you're doing this, there's someone else to represent, right? I mean, here there's no one else but you, and you're gone.
But what I'm saying is, let's say we had 6 named plaintiffs,
Mm-hmm.
and they picked off, or they did the same thing with all 6.
Right.
There would be the same issue of typicality or atypicality there with respect to the remainder of the class. And so our concern is,
But I assume there's another lawyer representing them, or you're representing them, and then even though your one client is gone, you're still present for the others, right?
well, named plaintiffs are, for the reasons that this court recognized in Machado, most employees are afraid to come forward because of retaliation. And in a case like this where there's a minimal amount of money at stake,
I
it's-
get all that, yeah.
it's exceedingly difficult to find somebody, and you can't blame them
I'm not
to
blaming them.
rationally come forward.
Trying to understand how this works, in a sort of the system where you're supposed to have the same interests as the people you're representing, but you're gone. But again, I'm not saying you're not right, I just don't understand how it's going to play out.
But let me
Well-
ask you, did you have to, was it mandatory for you to bring an interlocutory appeal?
It was not
Do you
mandatory.
have a right to an interlocutory appeal?
Well, we had the right to request an interlocutory
Right,
appeal.
but there's no right to the interlocutory appeal.
Correct, there is in federal
So
court,
the only
but
time you
not
could
here.
appeal would be at the end of the case.
Yes,
The class certification issue, I'm saying, you're saying the judge, lawyer got it wrong. The only time you could have appealed that would have been at the end of the case.
correct, which is what we did.
Right.
So going back to this dilemma, is it your view that the solution should be that we should grant interlocutory appeal so that a judge says, I'll have to wait to resolve the entirety of the case until I hear on the appeal?
No, not necessarily, Your Honor. There's actually, this court has recognized in earlier cases that there can be a benefit to having an individual case go forward, even if class certification had been denied. Like, so for example, here, if the case hadn't been dismissed and it had proceeded to an individual trial and Mr. Gammella lost, we probably wouldn't be here today because there would be no claim. On the other hand, if he won, we could have gone back to the trial court and renewed our motion for class certification based on what was learned at trial. And this is something Judge Young has done in federal court. He does an exemplar trial to inform class certification. So it's not necessarily the case that an interlocutory appeal should or can occur after every class certification decision. There's more to the case. There's more for the trial court to do.
Okay, so you're saying you are entitled to a trial even though the other side says, listen, we have given them, or we're prepared to give them, all that they would possibly get if they were to prevail at trial, that you'd still be entitled to a trial.
When the plaintiff has asserted his right to pursue a claim on behalf of others, yes, that's what we're saying.
Okay, so in a class action context alone, the argument, Your Honor, I've given them all their damages, I've given them all the attorney's fees, I've given them all that they would possibly win, you're saying that should not prevent a trial where there is a class certification denial?
Correct, unless the defendant is going to somehow stipulate that judgment's going to enter for the plaintiff and it's not going to adversely affect the plaintiff's ability to represent the class.
And did the defendant here stipulate to that?
They did not.
But you're here anyway?
No, they did not. They did not enter a stipulation that judgment would enter in Mr. Gammella's favor.
I see.
Mr. Churchill, let's say that you're right on numerosity. Do we decide the other three factors under Rule 23, or do we remand?
I think the proper course is to remand because that's a discretionary determination that the trial court never reached.
Are you, in terms of your argument that the Wage Act confers a special kind of right to a different kind of class certification or a lessened standard than Rule 23's numerosity requirement? As to that, what do you make of the decision in Salvis which says that the right under 149, Section 150 of the Wage Act is simply conferring the right to pursue an individual or class action in certain types of employment claims, while other employment claims are enforced only by the Attorney General's actions in filing the complaint or seeking indictment? Basically, it's sort of to distinguish between what the Attorney General can do and what an individual or a group of individuals can do.
Right. I think that was an argument that one of the amici made in their briefs.
It's not a bad one, is it?
Well, I disagree with it. I think that if you imagine the counterfactual of the language that omitted the ability to bring a case on behalf of others similarly situated in Section 150, and then if somebody brought a class action and the argument were made, oh, you can't do that because there's this other provision reserving to the Attorney General whatever's not granted to an individual for a private right of action, the response would be, well, Rule 23 has general applicability. There's no limitations on what type of claim can be pursued under Rule 23. You don't need a grant from the legislature in a statute to bring a class action in order to bring a class action, which is demonstrated through the discrimination law. There's no grant in Chapter 151B to bring a class action, but people have and regularly do pursue them because Rule 23 gives you the right to pursue any kind of claim.
You're saying that this does not talk about, I'm sorry, I don't understand your argument. I thought you were saying that it conferred a right, that the Wage Act conferred a right to class action.
I think it conveys, the statutory language gives employees a greater right than exists under Rule 23, in the same way that Chapter 93A conveys a specific right to bring a class action independent of Rule 23. So I think that language is significant, and it's language that the court has to give meaning to. Otherwise, it's surplusage.
Why would we have discussed Rule 23 in Salvis? We apply the standards of Rule 23 in Salvis to a Wage Act case, right? Were we just off base there?
Well, I would say two things. One is there's no indication that this issue was raised in Salvis. And we can't infer, just because the court discussed it under Rule 23, that the court intentionally decided that that was the only way that the analysis could proceed. Just because a person has a right to bring a claim under a standard under the Wage Act doesn't mean they can't also bring it under Rule 23. And in Salvis, again, that was a class involving thousands and thousands of people, so that you didn't have that numerosity issue at play. All right, I see my time is up. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
My name's Lisa Burton. I'm here on behalf of P.F. Chang's. I'd like to actually start with the premise of the facts of this case and then go into some of the arguments. In the facts of this case, there was a record that actually showed there was a handbook that included management policy that the rules had to be followed. There were posters. And in fact, there are the records that were required to be kept under the Massachusetts laws with regard to starting and stopping time.
Was there a record of what reporting pay was paid?
There was no record showing any reporting pay was paid because the various practices as set forth in the various declarations for the 6 different restaurants showed that each different manager had a different practice with regard to how they dealt with the issue.
No, I'm just saying, did anyone ever, did you provide records showing when you paid reporting pay?
There was no record that showed anybody got reporting pay, Your Honor.
Was it were you maintaining that no one got reporting pay, or that your records simply were not reflecting that they didn't get it?
It would be our position, Your Honor, that nobody was entitled to reporting pay.
Did they get reporting pay?
Nobody got reporting pay because nobody was entitled to
Of the
reporting pay.
7,000 people, nobody was entitled to it.
That's correct, Your Honor. Given the way the practices at the 6 different restaurants operated, it was the practice of the different restaurants to ask for volunteers. And in fact, as the evidence showed from the various declarations, that in one instance, some managers didn't ask until people were on their second shift. So at that point, they would have worked more than 3 hours. At other instances, people left early or volunteered before the start of the shift to say that they were ready to go and they'd like to leave early.
But Justice Link asked that to your brother. Your answer to the interrogatory isn't that bold, right? It's not no one was entitled to it. It's basically, our policy is not to do this, but you don't answer the question really, whether anyone really was entitled to it who didn't get it, right? You kind of leave that vague.
The answer, Your Honor, was accurate with regard to what her statement was. We looked at the records. There was no indication that anybody had reporting pay.
You didn't say in the answer, right, no one was entitled to it because they all did it voluntarily, right?
That is correct, Your Honor. That is not in my answer.
Okay, and I mean, isn't there an obligation for an employer to maintain records adequate to ensure compliance with the Wage Act?
Yes, Your Honor.
And do you agree that there is an obligation if somebody shows up at a workplace and they say, turns out we don't need you, you should go home, you've got to pay that person 3 hours?
That is correct, Your Honor.
And so should there not be any records when somebody works 1 hour and gets paid 1 hour as to something in the records that would enable an auditor or somebody else to say, well, in this particular case, the person volunteered to leave or said he or she was sick, and therefore an auditor reviewing it would be able to determine whether or not that person was paid in compliance with the Reporting Act or not?
Your Honor, I would state as follows. With regard to the requirements, P.F. Chang's complied. It recorded all of the time. With regard to an audit trail, which you are suggesting, the system that P.F. Chang's used may or may not have been able to do that. The question, though, was P.F. Chang's recorded the time, and it recorded the incidences when people may have left in other circumstances. Here, there's no requirement that the burden of proof is that we have to show why each and every person left. And in fact, here, we're actually dealing with a class claim where part of the standard that has to be met even under 93A when you're bringing a claim is that there has been an injury.
Okay,
And in fact,
but here's my problem. If you have what I'll call the good doobie employer, who basically says whenever somebody gets paid for less than 3 hours of work, there's a you must make a reference to indicate that it was voluntary because the good doobie employer wants to leave an audit trail to indicate that there was compliance. If the good doobie employer maintains that audit trail and it turns out there are violations, there can be a class action. If you have the bad doobie employer who leaves no audit trail, then you're in the situation that we're in now, where they can say, well, you can't show how many people actually volunteered, and therefore you can't show numerosity, and therefore you don't get a class action. Why is that fair?
That is fair, Your Honor, because when you're seeking to represent a class action and you're seeking to bring a claim, you should be able to show at least there is one other individual who has had a circumstance similar to yours that has caused the injury. In this case, unlike Salvis, there is not a policy or a practice that is recognized among management that there are issues with time shaving. In Salvis, the court actually was also looking at instances where there were hotline reports of the occurrences, where there were other audits and other information. And so in Salvis, the court was able to not only look at numerosity, but it looked at commonality and a common practice. Here, Mr. Gammella can't first show that this circumstance happened to anybody else.
So if he gets one other person, he wins?
No, it's not a question of whether the person he wins. He may get past possibly on the numerosity, but I think the more important question before this court here today is what was meant by similarly situated, and does Rule 23 apply?
Still haven't answered you agree that in my example, the good doobie employer has numerosity if the person turns out that the person failed to comply, correct?
Depending on the facts, yes.
Okay, and so, but the bad doobie employer now makes it much harder for a plaintiff to be able to establish numerosity.
Not necessarily, Your Honor. It may make it an extra step.
It means an auditor can't go through those books as when you gave them the 7,000, there were 7,000 times in which somebody was paid for less than 3 hours during the course of a day. Do you agree with that, roughly?
Yes, there were 7,000 instances. Some were a minute late earlier, some were several minutes, some were an hour.
But there were 7,000 arguable violations of the 3-hour rule, arguable, depending on whether or not they volunteered or not.
There are 7,000 instances at which you'd have to determine as to why that person left early.
And you maintain no records that would enable anybody looking at those records to be able to determine whether or not there was a violation of the Reporting Act.
Those records as they exist do not show that, correct.
And when you gave over those documents, did you delete the names of the people?
We provided the employee numbers.
Did you delete the names of the employee? Did you have in your records the names of those people?
We could ascribe the names to the employee numbers.
You could?
Yes.
You did not, even though they were requested?
We did not. We actually were working with counsel to figure out the issue to that question before discovery closed. We offered to provide a representative sample.
Why couldn't you just simply answer the question and give over the names so that he could have asked to find out whether any of those 7,000 people, in fact, had not gotten reporting pay when they should have?
Well, Your Honor, the discovery process in this case started in 2014. We provided the information. It was only a few weeks before the end of the close of discovery.
Because the information requested names.
And we objected on the overbreadth of it all, Your Honor.
Overbreadth?
Well, Your Honor, we objected to providing it under the rules, and we believed our objections were proper. Mr. Churchill did not pursue a motion to compel. He did not motion to increase discovery. He did nothing until he then filed for class certification, only with Mr. Gammella's testimony as his evidence. And in fact, Your Honor, in looking at the court and the record below, the decision to not certify the class action was appropriate. One, the appropriate standard is Rule 23. The issue that appears to be the argument or question raised is whether or not Rule 23 should be applied, or whether, in changing the language in the statute, you only have to show similarly situated.
I get you why it's Rule 23, but I still have trouble why he hasn't met the burden of proof on numerosity, given that we know 7,000 people worked less than 3 hours and didn't get paid, and you don't keep any records, so we're not sure what the answer is yet. And it's only the class certification stage. Doesn't doesn't that get you, it doesn't get you dismissed on numerosity, does it?
Well, I think
And
Your
are there
Honor,
any cases like that where they actually, we know there are 7,000 people who may be in and may not be in, and we know the record keeping is murky. It just seems like that gets you over the class certification motion to dismiss stage on numerosity.
I don't think that's the case, Your Honor, in this case. Let's look at this case.
Right.
Where Mr. Gammella was seeking to certify a class action, and he was trying to do it on behalf of himself and every P.F. Chang's employee in Massachusetts. Mr. Gammella only worked at 3 restaurants and only worked at the front of the restaurant. He did not provide any evidence, nor did he interview any of the people he worked with in the more than 7 years that he worked there. In the more than all of that time that he was there, the fact that plaintiff could not come up with another person suggests he couldn't find someone.
But what
Just as-
everyone's trying to say, I think, is this, saying, it's almost like, okay, who actually volunteered or who involuntarily went home without getting paid? Plaintiff has to find out because he's saying he went home without getting paid. There's a number of locations, there's a bunch of different managers, and the way you find out is you ask other employees, right? And the defendant's position is, well, we're not giving you the names. And the question, what's going on here is, isn't there an inference, since you're not given the names, that, number one, some of them must have gone home involuntarily, and/or number two, gee, there must be a reason they won't give the names.
Well, Your Honor, I think you again have to look at the facts of this case and Mr. Gammella's testimony.
But I think that we are. I think that in this example that Justice Lowy gave, he is giving
But,
the
Your
facts
Honor,
of this case.
with respect, Mr. Gammella testified that the reason he went home early on many occasions was that Dennis Chang, or Douglas Chang, and forgive me if I get his name wrong, was out to get him. And in fact, he testified that it was that gentleman and another employee who was under him who would send him home with the hopes of getting him to quit.
That's a bias issue that goes to weight. That argument helps you not at all. I mean, it might win at trial. Jury might be out 5 minutes, but it doesn't help you here.
Well, it does help me here because it deals with the issue of Mr. Gammella, who is seeking to represent this as a class matter.
So that goes to typicality or commonality?
It goes to many issues, Your Honor, even once you get past numerosity.
Doesn't go to numerosity, though.
It does not go to numerosity. It goes to typicality. It goes to adequacy. The other piece that Mr. Gammella can't make, even under Salvis, is a common policy or practice that has caused the damage.
Well,
And-
but that seemed weird that when you argue that, because the commonality is you're working 3 hours and getting paid less than 3 hours. I mean, working less than 3 hours and not getting the full 3 hours, isn't it? It's kind of an easy class action.
But, Your Honor, I believe if you took that position, you were actually forcing employers to say to an individual, and it doesn't matter who the individual is, be it a small employer or a large employer, it is not in your interest to let anybody go early until they've worked the 3 hours, because you're going to be responsible for paying that if we take that inference.
No, it means you need to make a reference on the record that the person volunteered.
But, Your Honor, there is no requirement that we put on the record that somebody
There
volunteered.
may not be a requirement, but you could have done so. Your policy could have said, we're going to ensure compliance with it. I gather, by the way, there's indication that no one was aware of the policy regarding the 3-hour rule, or
That is not accurate, Your Honor. It was posted in every single restaurant, and the manager's handbook, and contrary to what Mr. Churchill said, it wasn't just first created in 2014. If you look at our citation, it was that was the first volume we had, and that was an updated volume. And we had earlier incidences of the management training that talks about the requirement to let people.
And that same policy could have said, in order to ensure that we're going to be complying with the reporting pay obligation, if somebody is paid less than 3 hours, you need to document that it came as a result of them asking so.
The policy could have said that. It was not required to. I'd like to, though, come back to this question about the standard, because here, I think one of the questions is clear. Mr. Gammella consistently through this matter was pursuing it as a Rule 23 action. One of the issues that has come up in this case is the question of whether or not adding the language similarly situated into the Wage Act creates a lesser
I
standard.
actually think that's a simpler, tell us what happens. You know, we're concerned about buying off lead plaintiffs. The case law doesn't like that. Isn't that what's going on here? Now, but I don't know what to do with the fact that there's no one else, but that's a whole separate matter. But shouldn't we just allow this case to proceed, because we can't allow you just to settle with one if there are 699 potential other ones, right?
Well, Your Honor, I would say that looking at the case law and looking at this situation, in this case, Mr. Gammella had his opportunity to present the class claim. He had the opportunity to complete discovery. He had that chance.
When did he have the opportunity to appeal in a mistaken, an allegedly mistaken class certification decision? When?
He did, Your Honor. When the first decision came out, he had an opportunity to take an interlocutory.
It's not one of right, is it?
It is one that he can ask for, Your Honor.
So what?
Well, Your Honor, it's something
So if
first.
somebody doesn't ask for an interlocutory appeal, that's it? Even though they don't have a right to it?
No, Your Honor, I'm not saying that, but I would point out that Mr. Churchill, in the testimony before Judge Gordon on this issue, talked about the fact that they made a decision as to which path to follow. Now, when you look at the facts when this tender was made, and that's what makes this different than the Supreme Court cases and the other cases that are cited. In those matters, and the concern of the court, which is legitimate, is picking off named plaintiff before you get to the point of even getting to consider the class question. Here,
Just a consideration of it or an appeal of it?
well, here, I would say it was first the consideration of it, and I'll address the appeal of it because of the way this case was handled. Because, in essence, Mr. Gammella is here. The question about the class mootness and, for lack of a better word, the picking off, as plaintiffs called it, that only occurred at the point in time where there was no class claim here. There was no class action present.
But you knew he was intending to appeal it.
Your Honor, many things can happen. He could have won the case and chosen not to appeal it. At this point in time, though, in the issue faced by this court and by Judge Gordon, who was looking at this issue, we're not just talking about a Rule 68 offer. After that was done, it then went to the question of mootness and a tender. And in that, the judge noted, quite honestly, is that, so in essence, you're telling me, and to have a trial whose only real purpose is to produce the finality required for an appeal, that seems like an awfully, and we stated, expensive test. And Judge Gordon said yes, and an awfully inefficient way for you to proceed and for us to proceed. Because by entering judgment at that moment in time, Mr. Gammella had the right to appeal that decision, and he has the right to appeal the class decision. It's a question of the timing of this that is critical.
So are you saying he does or does not have the right to be here?
Mr. Gammella has the right to be here and appeal. He's appealing the question of the dismissal of his claim because of mootness. The fact that we made a tender and dealt with his claims dealt with the question of not putting the court and the system and the parties through a costly trial to get to the question of class certification,
Excuse me,
which
I
is
thought
here.
your argument was that we don't have subject matter jurisdiction to entertain it.
We had no subject matter jurisdiction as to Mr. Gammella's claim. Mr. Gammella's claim at that point in time, Your Honor, was only as his claim as an individual. And in fact, if he proceeded to trial, he would be proceeding as an individual.
When does he get to appeal the class certification decision? Not at all? Because we don't have subject matter?
No, he gets to appeal that at the end of the trial. One, on this question here, whether the court engaged in error in dismissing his claim. And then two, because the issue of the original class certification was out there. It wasn't appealed then, but we are now doing it all. He has standing because we are here, Your Honor. And it wasn't that we agreed he could appeal.
So he has, even if the judge is correctly dismissed his individual claim, he has standing to appeal the class certification claim? You agree with that? I'm just trying to understand your position.
I would say at that point in time, Your Honor, there's a question of who is in the class. But at that point in time,
So even though his case is done and
It-
properly dismissed, he has the ability to appeal the class certification case?
yeah, in this factual circumstance, Your Honor.
Okay, in what?
In this circumstance, because in this matter, his case was ended by the decision on a motion to dismiss, which is an appealable issue. At that moment in time, he is able to appeal that issue, and he's also able to appeal the class issue, which he has done here.
If the judge was wrong on numerosity, why do you say we should reach commonality, typicality, and predominance?
Well, Your Honor, and I do recognize my time is up. When you look at the facts, once you get past numerosity, you have to look at typicality. And you have to look at, is Mr. Gammella typical with the class he seeks to represent?
I understand. I'm saying, why not remand? Why are we deciding that, since there's a discretionary issue going on?
It is in this court's discretion if it thinks that it should be remanded, but this court also has the ability to look at and make the determination based on the record before it, whether or not the other characteristics are met. And in fact, if this court agrees that Rule 23 is the appropriate standard, in the full application of Rule 23, the decision should stand.
Should we also decide the issue of whether, if the case was properly dismissed and the class certification was improperly dismissed, he has the ability to keep pursuing this? Because that's all that this is really about, whether he gets to keep the class certification going. So are we supposed to decide that, and can we decide that on this record? Because that's what this is about.
Your Honor, on this record, whether it was properly dismissed, Mr. Gammella, at the end of the day, he would be in the same position as if he had won at trial. And therefore, I would say that the answer is, if after winning at trial, he could appeal that decision, this would put him in the same
appeal of the decision
position.
is kind of a silly issue in certain ways, because he's won. Whether it's dismissed or moot, it's his relationship to the class action. You paid him everything he wanted, but he wants to keep pursuing a class, and his individual client has basically got one, and we don't know anything about any of the others. I'm just trying to understand what we can do on that.
Well, generally, Your Honor, there are other people that would then take up that appeal, but I would say, if that is the case, and in this circumstance,
No, he's the only one here on the appeal. This is it before us, right?
so, Your Honor, I would say that at that point in time, he has the right to appeal it.
The question was different.
I'm sorry.
Do we have the ability to decide, do we decide that question on this record? What happens? And if you don't know.
I don't know, Your Honor.
I think the question is, are you going to claim that he's not typical because after all, you've already paid him all that he would win?
Well, Your Honor, I would say that that issue is not before us here, so I can't say what argument I'm going to make unless I'm talking to my client.
But isn't that what that's what the U.S. Supreme Court left open, that someone bringing such a claim that's ended can continue, but then you've got this open issue about typicality that's going to come up immediately, and they've left that undecided, haven't they?
Yes, Your Honor.
Okay.
All right, thank you.